Hi, everyone. Welcome to another episode of the Ask Amity Show. I'm Jennifer here with Cindy, my partner. So today we'd like to talk to you about husband and wife in California and community property with rights of survivorship. So to fully understand what a right of survivorship between married couples means, it's important to first discuss community property. So California is what's called a community property state. So what does that mean? So generally, anything that spouses acquire during their marriage is considered community property. So it means that they jointly own it. So this would include any assets, debts, income that is generated during their marriage would be considered community property. But this does not include any gifts or inheritance, because any gifts or inheritance received during their marriage is considered that spouse's or that receiving spouse's separate property. And then additionally, any property or assets or debts that are owned prior to the marriage is also that spouse's separate property. So it's important to note that only married couples and domestic partners may hold title to property as community property.
So what is then community property with right of survivorship? So a right of survivorship gives the surviving spouse the right to own the deceased spouse's share of the property. So for example, in a scenario with a married couple who owns a home as community property with the right of survivorship, if the husband passes away, the husband's share of the property will automatically be transferred to the wife. So this would then eliminate the need for probate. The wife would then own 100% of the property upon the husband's passing. Spouses who own title to property as community property with the right of survivorship cannot transfer their share of the property to another party other than his or her spouse. So it's only available to married couples. If you are a mom and daughter or father and son or siblings who want to own property, you cannot hold it as community property with rights of survivorship. This is only reserved for married couples. If you fall into the other category where you're not a married couple, but you want to hold property jointly, you would hold either as joint tenants or tenants in common. So, and you might ask, how do I know, I've already owned property with somebody else. How do I know how this property is held? Well, how do I know that? Well, you would know that through the deed. Usually it's called a grant deed. If you purchase a property, you would get a grant deed. And that's recorded with the county assessor's office in the county in which you live or in the county in which the property is located. So you'd know how the title is held with this deed. And that, again, it's public record and you can find out with your county. So that's all for today. And for California husband and wife right of survivorship, let us know if you have any questions or comments or thoughts about the topic or anything else that has to do with estate planning or probate. Let us know in the comments, and please remember to subscribe to our channel.